All right, let's put this to context now. And joining us in studio to speak about this is the man at the center of this case, the defense lawyer for Sarah Cohen. This is Philip Murgor. Thank you so much, Senior, for joining us tonight. Perhaps the question that Kenyans need to know tonight is: your client walking scot-free, or has your client walked out of this case?
First of all, good evening, Ken, and good evening, viewers. This saga involving Sarah Cohen started over 3 years ago. And to put it in context, start by recognizing the fact that there is a ruling pending on Tuesday next week. So, got any undue pressure on those. Having said that, should say that once the DPP, this case being the ultimate prosecutor, decides he's not going to pursue the case, yes, I expect that is the end of the prosecution for now. However, an inquest has been ordered, and if the presiding magistrate who hears the inquest determines that an offense has been committed by person or persons, they can recommend to the DPP that they be.
Okay, so you and I have spoken about this case for quite some time, and right from the beginning, I have followed through this case, and one of the things that has always come out of our talks is you felt from the beginning that this case was actually headed nowhere, and after last month's withdrawal, you actually invited for new investigation, Senior.
Ken, it is true that from the very outset, even when before she was charged, we always insisted that the process should be above board, and initially we facilitated that. We stood back and allowed the investigators to do their work. But it should be recalled that on the 12th of September 2019, Sarah Cohen was charged by the DPP on the recommendation of the DCI, Mr. Kinoti, without a scrap, without an iota of evidence, contrary to what is required under the new constitution. By the time you come to court in the present day under the new constitution, the entire evidence bundle should be attached to the charge sheet, or the information as it is called in the High Court. There was not a scrap of paper, and there wasn't for months. So I like to say that when we hear the DPP about the difficulty that he experienced carried on his work, this is one. There appears to have been pressure to prefer charges on the promise from the DCI that he would provide the evidence later, and he never did.
Okay. And now the DPP is saying they're not interested in pursuing this further. I know there's a ruling that will be made next week based on that withdrawal, but paint for us a picture of the likely road that an inquest will take, different from the process that has been going on.
First of all, the DPP has not said he is no longer interested in pursuing the issue of the murder of Tob Cohen. To the contrary, no. He is very much alive to the fact that as long as this is considered a homicide or a murder, it is his duty to ensure that somebody or those who committed this offense are brought to book. All he has done is determine from the evidence available to him now that it is not possible to proceed with that evidence as it is. In the letter that you referred to, he referred to contradiction. And in the court today, his officer indicated that when Senior Detective Mr. Gashomo said that he was forced to append his signature to a false and false affidavit, which contained a whole bunch of lies, it placed the DPP in a very awkward position where it's pointless to proceed at this stage.
Okay.
Now, the process by which an inquest is conducted is not very dissimilar to trial, except that there is no accused person. everybody is called as a witness. Every single person is called as a witness. Everybody who had recorded a statement is called as a witness. Anyone who has information that is useful is invited as a witness, or summoned as a witness. And, you know, it will be an interesting inquest, because we think and hope and expect that Judge Kinoti, who gave so many press conferences about this case, will be the first witness called and tested.
Okay, very interesting. And this is a personal question to you. As you are among one of the youngest DPPs to ever serve this nation, if you cross that line now, would you say, if you're on the other side, that the decision that has been taken right now by the DPP is a decision you would have taken several years ago if you're still the DPP of this country?
First of all, I wasn't that young when I was appointed. My colleague Noordin Haji appears to be much younger than I was when I was DPP, so maybe he will take that credit. But having said that, I also worked in similar circumstances. I worked with a very difficult DCI called Joseph Kamau, and you know, took a lot to contain him. But I can tell you I would have done things slightly differently, and which is I would never have accepted preferred charges where there was not enough evidence.
Okay.
So I would just have done things a little different.
Okay. As I let you go, one final one. We know this case has not been adjudicated to the end, so the threshold of double jeopardy has not been met here. So in future, if there is additional evidence that probably would link your client, do you think the DPP will go ahead and charge if they could surface alternative evidence that could now be carry more weight?
It will be his duty to prefer those charges if there is sufficient evidence to link not only my client, but a whole lot of suspects who we have continuously identified in our correspondence to the DPP. We expect that he would be able to charge whoever is involved, because Tob Cohen was brutally murdered by someone.
All right. Thank you so much, Senior, for sharing with us tonight. And we'll definitely be talking in the coming days about this case. But have a good evening. And of course, this is where we take our next break. When we come back, we'll be doing some business. Stay with us.